Yes. Go ahead.
May it please you, my lord. This is the continuing matter of the Queen against Mr. Andre Bryan, Mr. Tomrick Taylor, Mr. Michael Whitley, Mr. Dylan McLean, Mr. Lamar Simpson, Mr. Tariq James, Mrs. Stephanie Christie, Mr. Fabian Johnson, Mr. Jazeel Blake, Mr. Roel Taylor, Mr. Joseph McDermott, Mr. Jermaine Robinson, Mr. Andre Golding, Mr. Brian Morris, and Mr. Ted Prince. They are jointly indicted for offenses under the Criminal Justice Suppression of Criminal Organizations Act. Trial commenced in this matter, my lord, on September 20, 2022. Verdict delivered on March 8, 2023. Representation remains the same, my lord. The accused persons before the court are for sentence hearing today.
Yes, go ahead.
Good morning, ladies and gentlemen. Mr. Andre Bryan, thank you, sir. Mr. Tomrick Taylor, thank you. Mr. Michael Whitley, Mr. Dylan McLean, Mr. Lamar Simpson, Mr. Tariq James, Miss Stephanie Christie, Mr. Fabian Johnson, Mr. Jazeel Blake, thank you. Mr. Royal Taylor, thank you, sir. Mr. Joseph McDermott, Mr. Jermaine Robinson, Mr. Andre Golding, Mr. Brian Morris, and Mr. Ted Prince. Thank you all. All present, Chief Justice.
Thank you very much. Now we're now at the sentencing phase of the trial, and at the commencement of this sentencing, I will make a few general remarks concerning the principles applicable to sentencing generally, and then specifically to the circumstances of this particular case. It was in Misha Clement and the Queen, where the Court of Appeal of Jamaica, speaking through Justice Dennis Morrison, then President of the Court of Appeal, indicated that the sentencing judge must always have in mind the four classical principles of sentencing, which are retribution, deterrence, prevention, and rehabilitation. The President went on to indicate that the sentencing judge in each case is to apply these principles, or any one of them, or a combination of them, depending on the circumstances of the particular case. The objective being to impose a sentence to fit the offender and at the same time fit the crime. The Court of Appeal indicated that in arriving at the appropriate sentence, the sentencing judge is not at large. There was a view that was previously held, namely that ultimately every sentence imposed represents a sentencing judge's instinctive synthesis of all the various aspects involved in the punitive process. That view has now given way to the recognition of the need for greater objectivity, transparency, predictability, and consistency in sentencing. And it has been said that in order to have a coherent, transparent, and justifiable sentencing system, relevant principles must not only be articulated, but prioritized and weighted. Part of that consideration involves recognition of the Criminal Justice Reform Act of 1978, particularly Section 3.1 and Section 3.2. And Section 3 requires the judge to consider whether an alternative to imprisonment is appropriate in the circumstances of any given case. And Section 3.2 indicates that where the judge is of the view that no method of dealing with the offender other than imprisonment is appropriate, then reasons should be given. And that was expanded upon by the Court of Appeal in Dwayne, Strawn, and the Queen, where Justice MacDonald Bishop examined Section 3 of the Criminal Justice Reform Act in more detail, where her ladyship indicated that the purpose of Section 3 was for the purpose of determining whether any other method of dealing with such persons is appropriate, and any other method meaning any other way other than imprisonment. And it is to ensure that the sentencing court takes into account the nature of the offense and to obtain all relevant information relating to the character, home surroundings, physical and mental condition of the offender, and then deciding what is the appropriate sentence in the circumstances. It is important to recognize that although rehabilitation is an objective and a laudable goal, it must be considered in light of the fundamental purpose of the criminal law and the criminal trials. The purpose of the criminal law is to make known what conduct is prohibited and to punish those appropriately who violate the law. Where there are crimes or serious crimes in view, the court cannot lose sight of the fact that the fundamental role of the criminal law is punishment. That is why punishments are attached to crimes. And here the Court of Appeal of Guyana in Nero against the state, beg your pardon? Nero and the state, 98 West Indian reports at page 373, citing Justice Hilbery of the English Court of Criminal Appeal in the Queen against Ball, where Justice Hilbery said, in deciding the appropriate sentence, a court should always be guided by certain considerations. The first and foremost is the public interest. The criminal law is publicly enforced, not only with the object of punishing crime, but also in the hope of preventing it. A proper sentence passed in public serves the public interest in two ways. It may deter others who might be tempted to try crime as seeming to offer easy money on the supposition that if the offender is caught and brought to justice, the punishment will be negligible. Such a sentence may also deter the particular criminal from committing a crime again or inducing him to turn from a criminal to an honest life. The public interest is indeed served and best served if the offender is induced to turn from criminal ways to honest living. Our law does not, therefore, fix the sentence for a particular crime, but fixes a maximum sentence and leaves it to the court to decide what is, within that maximum, the appropriate sentence for each criminal in the particular circumstances of the case. Not only in regard to each crime, but in regard to each criminal, the court has the right and the duty to decide whether to be lenient or severe. In the same case, the Court of Appeal of Guyana citing the Court of Appeal of New Zealand and the Queen against Radich, where Justice Fair said, one of the main purposes of punishment is to protect the public from the commission of such crimes by making it clear to the offender and to other persons with similar impulses that, if they yield to them, they will meet with severe punishment. In all civilized countries, in all ages, that has been the main purpose of punishment, and it still continues so. The fact that punishment does not entirely prevent all similar crimes should not obscure the cogent fact that the fear of severe punishment does and will prevent the commission of many that would have been committed if it was thought that the offender would escape without punishment or with only a light punishment. If a court is weakly merciful and does not impose a sentence commensurate with the seriousness of the crime, it fails in its duty to see that the sentences are such as to operate as a powerful factor to prevent the commission of such offenses. On the other hand, justice and humanity both require that the previous character and conduct and probable future life and conduct of the individual offender and the effect of the sentence on these should also be given the most careful consideration, although this factor is necessarily subsidiary to the main considerations that determine the appropriate amount. Now, in Jamaica, there has been the scourge of criminal organizations, and it has taken its toll on our citizens and visitors alike. At least, that is the view of the legislature, whose responsibility it is to pass laws for good government and good governance. It was thought that the existing criminal calendar up to the passage of the Criminal Justice Suppression of Criminal Organizations Act was inadequate to address the new criminality that had emerged. It was thought that the usual staple of murder, firearm offenses, along with principles of accessory liability, was insufficient to address the new forms of criminality. Existing criminal practice and procedure often prohibited the prosecution from placing before the court the full scope of the criminality involved. That this is so is made clear by the preamble to the Criminal Justice Suppression of Criminal Organizations Act, which governed or set out the offenses for which these persons now to be sentenced have been convicted. And if we turn to the preamble there, this is what we find. The preamble reminds us that this is an act to make provision for the disruption and suppression of criminal organizations and for related matters. It goes on to say, whereas the activities of criminal organizations represent a danger to public order and public safety and the economic stability of Jamaica, and whereas the existing laws of Jamaica fail to adequately disrupt, suppress, or otherwise deal with organized crime and the activities of criminal organizations effectively, and whereas it is necessary to target the leaders of criminal organizations and criminalize the management of and related conduct in connection with criminal enterprises that are involved in criminal activity, And whereas the pervasive presence of criminal organizations in many communities is harmful to the well-being of those communities, and therefore it is necessary to criminalize participation in and the promotion of the activities of criminal organizations. And whereas it is desirable to restore a sense of security in the Jamaican society and strengthen the capacity of law enforcement agencies to deal with crime effectively. And then it goes on to speak about the passage of the legislation, and we are now where we are. So that is a broad context there. Now, this particular statute is significant for a number of reasons. So seriously has the legislature taken the threat of criminal organizations that the definition of criminal organizations has been cast in very wide terms. In essence, it says that any group, gang, alliance, network, combination, or other arrangement among 3 or more persons, whether formally or informally affiliated or organized, or whether or not operating through one or more bodies corporate, or other associations, A, that has as one of its purposes the commission of one or more serious offenses, and it has others that are not relevant to our circumstances here, then it is a criminal organization. So it may very well be that what used to be regarded as regular conspiracies in the past can now be prosecuted under this legislation. And as I understand the legislation, there is no need for the 3 or more persons in number to do anything other than form an alliance with the purpose or purposes of committing one or more serious offenses. So the statute does not require multiple commission of offenses. It does not require that any offense be committed for it to be a criminal organization. Once you have 3 or more persons and there's an alliance between them and it has as one of their purpose the commission of one or more serious offense, then it's a criminal organization. It does not require it to be ongoing, so the Crown doesn't have to prove that they intend to commit 8, 9, 10, 12, 13, 14, 15, 16 offenses. Coming together, 3 or more, to commit one serious offense, if that is what you come together to do, is sufficient to make you a criminal organization. The legislature did not leave it there. The statute has set out what I call an overlapping set of circles of offenses, and they make great effort, that is the statute now, makes a great effort to criminalize a whole variety of offenses, from formation and membership of a criminal organization to recruiting members, leading a criminal organization, the facilitation of serious offenses by or on behalf of a criminal organizations. The statute seeks to criminalize those persons who may not be members of the criminal organization but give counsel, guidance, and instruct the criminal organization in the furtherance of its criminal activities, and so on. Now, in this particular case, the offenses in view are leadership of a criminal organization, for which the maximum penalty is 30 years, facilitating a criminal offense, where On first conviction, the sentence is 20 years, and membership of a criminal organization with a maximum penalty is 20 years. So the statute then has singled out being a leader of a criminal organization to be the one deserving of the most severe punishment of the three offenses that are the subject matter of this indictment and for sentencing. In addition to that, there are offenses under the Firearms Act, and just to make the point that the Firearms Act in view here, the firearm offenses in view here would have to be sentenced under the repealed legislation and not the new legislation that was passed in 2022. Now, as far as the methodology is concerned, there seems to be an ongoing debate as to how one determines the starting point. Certainly for the majority of our cases here in Jamaica, the methodology has been to identify the sentencing range and then identifying the starting point within the sentencing range. And that came out in the Misha Clemens case. But even within that case, the President of the Court of Appeal at paragraph 30 had this to say about a case from the Republic of Trinidad and Tobago, the Court of Appeal there. This is the case of the of Aguilera and others against the state. And this is what our Court of Appeal had to say about that case. Learned President said, before leaving this aspect of the matter, we should refer in parenthesis with admiration and respect to the recent judgment of the Court of Appeal of Trinidad and Tobago in Aguilera and others against the state. In that case, after a full review of relevant authorities from across the Commonwealth, the court adopted what is arguably a more nuanced approach to the fixing of the starting point, explicitly influenced by the decision of the Court of Appeal of New Zealand in the Queen against Tor and others. The court defined the starting point as, quote, the sentence which is appropriate when aggravating and mitigating factors relative to the offending are taken into account, but which excludes any aggravating and mitigating factors relative to the offender. So factors such as the level of premeditation and the use of gratuitous violence, for instance, to take but a couple, would rank as aggravating factors relating to the offense and therefore impact the starting point, while subjective factors relating to the offender, such as youth and previous good character, would go to his or her degree of culpability for the commission of the offense. The President continues at paragraph 31 of Misha Clemens. We have mentioned Aguilera and others against the state for the purposes of information only, but it seems to us that, naturally, subject to full argument in an appropriate case, the decision might well signal a possible line of refinement of our own approach to the task of arriving at an appropriate starting point in this jurisdiction. And so in my view, that time has come, and it is now. So, Aguilera then, citing Justice O'Regan of the Court of Appeal of New Zealand in the Queen against Tor and others, indicated the following. The modern approach to sentencing uses as a reference point a starting point, taking into account aggravating and mitigating features of the offense, but excluding mitigating and aggravating features relating to the offender. Put another way, a starting point is a sentence considered appropriate for the particular offense. The combination of features for an adult offender after a defended trial. When we use the term starting point in this judgment, that is what we mean. Justice O'Regan continues, setting the appropriate starting point for sentencing will involve an assessment of a number of features which add to or reduce the seriousness of the conduct and the criminality involved. As this court made clear in Mako, that is another New Zealand case, it is the particular combination of those variable features which requires assessment for sentencing in each case. And as the court, that is in Mako, went on to say, the task of placing the particular combination of features comprising an offense in its appropriate relative position on the scale of seriousness is a matter of judgment, calling for the careful exercise of the sentencing discretion. Features of the offending requiring assessment cannot be exhaustively listed, and this must obviously be so because there are a whole variety of offenses, and the circumstances of offending will vary from case to case and from defendant to defendant, even within the same case. So, the Court of Appeal of New Zealand went on to say, and though they were speaking in the context of offense of grievous bodily harm, but the general idea, I think, applies across the board to all offenses except for those where there are mandatory penalties. It says, as the court did in Mako, we propose to set out a number of factors which will bear on the assessment of the appropriate starting point. And in the context of, well, the particular offense there, the appropriate sentencing band. We do, however, emphasize that a sentencing judge needs not only to identify such factors, but to evaluate the seriousness of a particular factor. For example, premeditation is identified as a factor, but it may vary in particular cases from full-scale planning and orchestration of a concerted vicious attack to a period of a few minutes or so after a perceived slight during which the offender decides to take revenge. The evaluative task is an important aspect of sentencing. Without it, there would be a danger of a formulaic or mathematical approach to the assessment of sentencing starting points. So they refer to now things such as extreme violence, premeditation, serious injury, use of weapons, attacking the head of the victim, the facilitation of crime, perverting the course of justice, which would be a post-offense conduct where they had multiple attackers, vulnerable victims. Was it a home invasion? Was it gang warfare? Was the target a public official? Was it vigilante action? Was it a hate crime? And so, in effect, then, it suggests some flexibility in determining the starting point in relation to different offenses and inferentially different offenders. So conceivably, you can have different starting points for different offenders in the same case and in the same count in the indictment. Now, in the particular case here now with which we are concerned, it must be borne in mind that the Crown sought to prove the case against the defendants by adducing evidence of the commission of serious offenses over a period of time. And the significance of that is this. And before we get to the seriousness of that, we need to again put it in context. The statute does not place any limitation on how the Crown may choose to prove membership of a criminal organization. The Bryan case from Bermuda, which went to the Privy Council, is one way of proving membership of a criminal organization. But there's nothing to say that if there's evidence that the same group of persons are involved in the commission of serious criminal offenses over a period of time, that the inference cannot be drawn, that the best explanation for the involvement of the same group of persons committing these serious crimes is that they are members of a criminal organization. So that is how the Crown sought to prove membership of the criminal organization and also sought to establish who was or who were the leaders of the criminal organization by adducing evidence of the background leading up to the commission of the offenses. For example, who gave the directions to commit the crime, who was involved in the planning, who gave in permission as to how money, a significant resource within this particular criminal organization, was spent. Not getting into the business of the acquisition now, but the spending of what was obviously a very significant resource within this particular criminal organization. In this particular case, for the defendants who are here remaining, the evidence discloses that, but for their arrest, it appears that their life and activity in this organization would have continued uninterrupted. The two witnesses who gave evidence for the Crown, well, they readily admitted that they were members of the criminal organization. One was the accountant, and the other was the driver. So we refer to them as the accountant and the driver. And they readily accepted that they were members of a criminal organization. And that, incidentally, gives us 2 out of 3. The magic number here is 3. And one, based upon the evidence, was not being investigated by the police. Somehow he was able to manage his life of criminality, that he did not come to the attention of the police. And even when he went to the police to tell them about who he was and what he was involved in, he was greeted with more than a healthy degree of skepticism by the police. And it was while in their presence that a call came in, and it is said that the voice of Mr. Bryan was recognized, that the police began to give some credence to him, and hence he became a witness for the prosecution. So, based upon the evidence, he is one who, although a member, had decided to abandon his life of crime, if not permanently, but at least for now, and so make himself available to the Crown. The other person, and that one about whom I just spoke, was the driver. The other person, though, he was the accountant, and he was arrested by the police. He was charged, and he had the benefit of counsel, and I suppose his lawyer, having explained to him the realities of his circumstances, decided to give evidence for the Crown. The others chose, as they are entitled to, go for a trial. Nothing is wrong with that, but there are always consequences to actions and decisions. So it means that in sentencing, the discount that would normally accompany any pleas of guilty, it just simply does not arise in this particular case. There's one defendant who, well, albeit belatedly, as it came out in the social inquiry report, accepted that he was a member of a criminal organization. And I suppose that's an important first step to any prospect of rehabilitation. But nonetheless, he sat back, as he was entitled to do, to put the Crown to proof, as he was entitled to do. And of course, he's always entitled to change his mind, as he apparently has, and accepted that he was a member of the criminal organization, and so now he's asking the court for some degree of leniency, which must be taken into account. Now, as I indicated, the two decisions from the Court of Appeal, Clemens and Strawn, requires the court to approach the sentencing in a systematic way. So the first order of business is to determine whether the offenses committed in this case can be addressed by means other than imprisonment. Having considered the circumstances of this particular case and the evidence led in the case, the court is not of the view that there can be any sentence other than imprisonment. The offenses reveal extreme violence, and in some cases culminating in the death of our citizens and arson, and there was no hesitation to use violence to further the ends of the criminal organization. And the defendants here, all of them, clearly were members of the organization when it was known to them over time what the organization was about, what it was engaged in, the acts that they were prepared to do, and up to the point of their arrest, there's nothing to indicate that, well, other than the driver, nothing to indicate that they were about to rethink or abandon their life of crime. And so, in the circumstances, custodial sentences are appropriate. The only remaining question now is how long it should be, that is the sentence for each particular defendant. And so, that being said, we go now to the first person on the indictment, that is Mr. Bryan, who was convicted after a contested trial on 8 counts, counts 1, 6, 7, 8, 11, 12, 15, and 19. Count 1 was leadership of a criminal organization, and there were 7 other counts of facilitating serious offenses. Now, I must say 2 things. Yes. What are those 2 things? To repeat something that I had said earlier, that the Crown sought to establish leadership of the criminal organization by referring to and proving the commission of serious offenses. There were instances, at least 2, where the offenses were not indicted, are not charged as a part of this indictment. And then there were offenses that formed part of this indictment. So the question is, was it legitimate for the Crown to use the unindicted offenses, serious offenses, in proof of 1, the existence of a criminal organization, and 2, leadership of the criminal organization? The answer to that, which I gave during the trial and now, is that it is legitimate for the Crown to do so, and it does not violate the principle in making, and the Attorney General, once the evidence is relevant to an issue in the case. And one of the issues in the case, well, there were 2 primary issues in the case in respect of Mr. Bryan. 1, did the criminal organization exist? And 2, was he a leader or the leader of the criminal organization? And so the Crown was entitled then to adduce evidence of involvement of serious offenses not indicted to establish leadership of the criminal organization. So now, let us go now to the relevant facts, summary of them. The period of the time covered by the indictment for leadership is January 1, 2015 to June 30, 2019. That is the period covered by count 1. Now, in seeking to establish leadership here, the accountant, in effect, was saying that when it came to, other than a few instances, the expenditure of money, oftentimes, I won't say every single time, but oftentimes, the expenditures were conducted on the instructions of Mr. Bryan. And, of course, the accountant, by virtue of his role in the organization, would be in a position to know that kind of information. He indicated that he has no written records of his expenditure, and the explanation that he gave was that in 2018, when the state of emergency was being declared and coming into Spanish Town, you took, my words now, not his, the precautionary step of destroying the records because he wanted a situation to arise that in the event that he was held by the police, he would not be found with the records relating to the finances of the organization. And so that was his explanation as to how it is that at the time of testifying, he had no records in support of his assertions. So that's one aspect of it. The accountant went on to refer to a shooting incident by Fisheries, and there were two Fisheries incidents, one covered by the express terms of the indictment, that counts 7 and 8, and this first one to which I'm referring was not covered by the terms of the indictment, and it was being used by the Crown to establish membership of persons other than Mr. Bryan, as well as Mr. Bryan being a member and also being the leader of the criminal organization. So this was a shooting incident across the road from the National Police Academy in Twickenham Park, St. Catherine. On this occasion, the narrative is that Mr. Bryan had told the accountant and Mr. Blake is one of the persons convicted in this trial and to be sentenced, to go down by Fisheries to see if targeted persons, we didn't have the names, but targeted persons were there. And the accountant and Mr. Blake, having received these instructions, carried them out. The accountant indicated that he and Mr. Blake drove down to Fisheries where the persons were. According to him, Mr. Blake, who was in the vehicle that the accountant was in at the time, made a telephone call, and listening to Mr. Blake's side of the conversation, in that call, Mr. Blake was indicating to whomever he was speaking to, so we're not saying at this point it is Mr. Bryan, the evidence doesn't make clear, but whomever he was speaking to, Mr. Blake was saying, well, the targets are here. Shortly after, the accountant indicated that another group of men that he saw, including Mr. Ted Prince, who is for sentencing here, arrived at Fisheries and began shooting. As I indicated now, the magic number, 3. So you have the accountant, you have Mr. Blake, you have Mr. Prince, and then you would have Mr. Bryan giving the instructions. So you're up to 4. So the shooting subsided. They returned to the house or the property from whence they came initially, and there Mr. Prince was said to be reporting to Mr. Bryan that although he missed the intended target, someone else was shot. The accountant also testified that a man called Terror and Mr. Andrew Golding, who is to be sentenced here, they too were reporting to Mr. Bryan that the shooting began as soon as they came out of the car. And evidence went on to indicate that Mr. Bryan was not too happy about this outcome. Clearly, inefficiency or incompetence here. The intended targets were not shot, and therefore Mr. Bryan was not too pleased about this. But nonetheless, that being the case, and one has to be realistic here now, this was a daytime shooting, and in all likelihood, police may arrive shortly after. So what was happening here now? According to the evidence, Mr. Bryan then told the accountant to pilot Mr. Golding back to Bucktown to hide the car that was known as a dumpy truck. And this evidence came up in the case when reference was made to a dumpy truck, and the witness was asked specifically to give specific instances of the use of this truck. And his explanation was that Mr. Andre Golding was the keeper of this vehicle, and he kept it down in Bucktown in the Rivoli area of Spanish Town, and whenever the vehicle was utilized, it was more often than not in the context of a planned shooting somewhere. And so the piloting now was meant to accompany the car driven by Mr. Golding back to Bucktown in Rivoli. And it was to be done in such a manner that Mr. Golding, the accountant was to ensure that the police were not around in the event that they wanted to or may wish to stop the vehicle. So in effect then, if you are in a daytime shooting, like all persons you have to work out now, the post commission behavior. What is going to become of the car? What if somebody has seen it? If somebody has seen it, it has to be hidden. So that is evidence showing that capable of showing that Mr. Bryan is a leader of the criminal organization, and it involved the accountant, Mr. Prince, and Mr. Blake. The
appears to be a health situation in relation to Mr. Bryan. It might be urgent that he be taken out as soon as possible.
Okay, let's find out what the health of the police speakers and find out what this health situation is. Yes. The officers find out, please. Steve. Okay. With Mr. Bryan for the time being, I will move on now to Mr. Tomrick Taylor. Mr. Tomrick Taylor was convicted on count 2 alone, being member of a criminal organization after a contested trial. How did Mr. Taylor get here? Well, the evidence of the accountant is that when he made his trip to Price Right to kill Dooley, and in this case with Dooley, the evidence disclosed that there was a determined effort to kill this gentleman. The totality of the evidence between the accountant and the driver shows that at least 3 trips were made. So the accountant is saying that when this is the accountant's first trip, not necessarily the first trip to kill Dooley, but the accountant's first trip to kill Dooley, Mr. Taylor was one of the persons who went with him. The driver indicated when the driver, made his trip to kill Dooley, who was eventually killed, Mr. Taylor was one of those with him. Now, when Dooley was actually killed, Mr. Taylor was not present, but what the evidence showed was that Mr. Taylor was ready, willing, and able to lend his assistance to the organization to kill this gentleman. So there is no evidence that Mr. Bryan spoke to him directly or gave him instructions, but the circumstances demonstrate that when he went along on the 2 trips on which he was identified as being a part of, it was quite clear that he knew that he was on a mission to kill, and on a mission to kill for and on behalf of the criminal organization. And by so doing, in my view, indicated that he had subscribed to and joined up with this criminal organization to engage in the business of murder, or at the very least, shooting with intent or wounding with intent, both of which are serious offenses for the purposes of this legislation. Now, the starting point here is to be deduced from all the circumstances of the case. This was a criminal organization that was in the business of killing persons. It used firearms, which means that they either had them themselves as their own property or had access to them. It tended to commit crimes in groups of 3 or more, which means that there were multiple attackers. The offenses were premeditated, and certainly in respect of Dooley, the killing of Dooley, or the efforts to kill him, he was to be killed in St. Andrew, and this is a criminal organization based upon the evidence that had its base in Jones Avenue, Spanish Town. So this was not a case of a spontaneous response to something that had happened. It would of necessity mean that whoever was going to kill Dooley had to find themselves at Price Right in St. Andrew and await the appropriate time and opportunity. So if you lend yourself and become a member of this type of organization, then it suggests to me that those circumstances are such that the starting point has to be upwards of 10 years. The maximum penalty here being 20 years. So the question is precisely where between 10 and 20. It is said that the maximum penalty, 20 years, is reserved for the worst of the worst. So I think in this particular case, an appropriate starting point is 17 years, 17, There are no aggravating circumstances personal to Mr. Taylor that would increase his starting point. That is Tom Rick Taylor. The mitigating factors. There's no evidence that he actually shot anyone despite his willingness to attend upon trial's right to murder another person, or at the very least be close enough to render assistance if necessary, or providing moral and emotional support to the actual shooters. He has no previous convictions. The social inquiry report indicates that he is now accepting responsibility. This is one of the persons, or the person that I referred to in my opening remarks, who accepted that he was a member of the criminal organization, so he has now accepted that. For the greater part of his life, he was not involved in criminal activity. The social inquiry report spoke to citizens in Demshapen, where he was known to the persons there as Fancy Ras. The citizens of Demshapen noted that, as far as they were able to determine, he was not known to be in any criminal activity. And from the rest of the evidence in this case, it doesn't appear that he was a hardcore member of the criminal organization, but nonetheless a member. His counsel urged the court to take a holistic approach and to consider the socio-economic and sociological circumstances. Counsel pointed out, as was indicated in the social inquiry report, product of a single parent, and his places of abode were in communities that were plagued by gang activity, and the defendant may have found it difficult to resist the activities that were going on around him. Counsel suggested that he is capable of rehabilitation, and that should inform the sentencing or the sentence that the court would pass. The preparers of the social inquiry report suggest that if he were allowed to be reintegrated into the society, he would have a support system. And since this is his first conviction, that is a factor that should be taken into account. It was also being urged by counsel that since he has accepted responsibility and involvement in a criminal organization, this should be taken as evidence of remorse, and that he has learned his lesson and has seen the folly of his ways. It is interesting to observe that some of the citizens of Jones Avenue remarked that in their view, Mr. Taylor had no reason to be involved in criminal activity, since his mother and his siblings who were overseas sent either money or clothes or material to enable him to dress in such a manner that he earned the name Fancy Ras. The residents also noted that he was a security guard at a hardware establishment and worked at nights. So at the very least, as a security guard, you would have some appreciation of wrong and right, even if it was lost on him before, but certainly part of his instructions would undoubtedly have been to keep order wherever he was placed and to prevent wrongdoers from engaging in untoward behavior as far as the hardware store is concerned. So all of those factors now have to be weighed. As I indicated before, and this is an example of that Mr. Taylor, the evidence suggests that Mr. Taylor would have continued his life of criminality but for his apprehension by the police. His economic needs were being taken care of, both by being employed and by his relatives overseas. The SCR also indicates that he himself said that despite his father's absence and non-contribution financially, his mother made every effort to ensure that he was sent to school. He said he enjoyed his childhood and engaged in the usual childhood activities. So in other words, despite the circumstances, the socio-economic circumstances to which counsel has referred, there's nothing to suggest that there was any inevitability about Mr. Taylor being involved in or with or becoming a member of a criminal organization. This is a man who made the decision to join criminal organization, went into it with his eyes wide open, knew what they were about, made not just one but 2 trips to kill this dually, so it was very clear to him. And while I keep in mind the classical principles of sentencing, namely retribution, deterrence, prevention, and rehabilitation, they do not have equal weight in all circumstances. When you're dealing with criminal organizations, particularly those that engage in the business of murder and arson, the protection of citizens and the population must take preeminence and priority over any rehabilitation. So it is prevention in the sense of preventing Mr. Taylor from committing any further crimes of this nature, at least for the period of time that he would be in prison. It is deterrence in the sense that persons who may not have previous conviction but who have decided to become involved in this type of criminal organization must expect significant punishment if caught, tried, and convicted based upon admissible and reliable evidence. The court notes that this trial went on for a year plus, and all during this time, Mr. Taylor's view was that the witnesses were lying on him. And now, having been convicted, it has suddenly dawned upon him that, just maybe, not in his case, maybe, the witnesses were speaking the truth about me after all. To my way of thinking, that is now a tactical decision made to have himself presented to the court as being remorseful, because he sat there from September of 2021 and he had all the way up until March of 2023. And the two witnesses were the first two witnesses who testified for the Crown, and their evidence was finished after a few weeks or months. So he had the rest of the time to think and to reflect on what the witnesses had to say. And if he was of the view then that, I'm really a member of the criminal organization, he could have changed his plea during that period. And so this suggestion now that he's now remorseful, I don't accept. I think he's now trying to curry favor with the court to say, well, if I say that I am now a member, if I say that I am remorseful, I will end up with a lighter sentence. Well, I'm sorry to disappoint Mr. Taylor. That simply won't work here. So this idea that he is remorseful, I don't accept it at all. He's saying now that he regrets his decision to become part of the gang, as it has caused his freedom. He has lost some family connections and so on. He's asking for lenience in the form of a reduced sentence. Shared his intention of starting afresh when he returns to society. Well, that would be a good thing if he does. And the report is also telling us that his mother has suffered severely in terms of her health has deteriorated significantly because of what she had learned about her son's involvement in this matter. So, start at 17 years. No aggravating factors to take it up. And as far as I am concerned, mitigating factor to bring it down would be the absence of previous convictions, which in my view would bring it down 2 years to 15 years. And so we are told that he was in custody for 5.5 years. So we take the 5 from the 15. That gives us what, 10? And then 6 months, another half a year take notes. So that takes us to what, 9.5? 9.5. And so now, Mr. Taylor, your sentence here now for being membership of not a criminal organization, but this specific criminal organization now, bearing in mind that it was an organization that had as one of its purposes, which would have been known to you, murder, or at the very least, shooting or wounding with intent. That is to say, intentional harm to the use of firearms to another person. And so if you voluntarily join an organization like that, then you should expect to be treated severely, well, in the context of the maximum penalty. So, Mr. Taylor, sentenced then on count 2, membership of a criminal organization is 9.5 years. Sir.
Just noting for the record that Mr. Bryan is back.
Yes. Thank you very much, sir. Where's Mr. Taylor? Stand, please. Can remove him from the dock now. We're finished with him. Thank you, sir. Thank you very much. Sorry. Oh, you wish a break? Okay. So we're going to take the break now until 11:45. So a health break for all concerned. So rise for 15 minutes and then return.
This honorable court rises for 15 minutes. God save the king. You may be seated, please. Ladies and gentlemen, Mr. Andre Bryan, Mr. Michael Whitley, Mr. Dylan McLean, thank you, sir. Mr. Lamar Simpson, thank you. Mr. Tariq James, thank you, sir. Ms. Stephanie Christie, Mr. Fabian Johnson, Mr. Jazeel Blake, thank you. Mr. Royal Taylor, Mr. Joseph McDermott, thank you. Mr. Jermaine Robinson, Mr. Andre Golin, thank you. Mr. Brian Morris, and Mr. Ted Britz. Thank you all present, Chief Justice.
All right, thank you very much. And now back with Mr. Bryan. He is now back in court. And so at the point at which we had broken, we're saying that evidence in relation to the fisheries incident, this is the one other than counts 7 and 8, would show that Mr. Bryan was indeed the leader of the criminal organization, and that Mr. Blake and Mr. Prince, of course, the accountant, were part of this criminal organization. There was another unindicted incident. This was in relation to the plan to burn down the Torpedo Loan Company. According to the accountant, he, Mr. Bryan, Mrs. Cole Christie, and Mr. Johnson and another had planned to burn down the store as arson under the Malicious Injuries to Property Act. And that particular type of arson is a serious offense for the purpose of the Criminal Justice Suppression of Criminal Organizations Act. The idea was that the store was to be burnt to the ground in order to convince the owner to apparently change his mind about some matter of importance to the criminal organization. The evidence went on to show that on a particular night, the accountant spoke to Mr. Golding and to Mr. Prince about burning down this building. The accountant ensured that police patrols were not nearby or in the vicinity, and he then called Mr. Golding and advised him of that fact. And then thereafter, smoke and fire were seen in the Spanish Town area. And then afterwards, Mr. Prince was indicating to the accountant how they had gained entry to the property and what they had done. But Mr. Bryan was part of the planning of this. And so here again, you have evidence of a serious offense being planned, showing the purpose of the criminal organization. And again, you have the magic number, 3 or more, that is the accountant, Mr. Bryan, Mrs. Cole Christie, Mr. Johnson. So that those two instances, shooting by Fisheries, which was unindicted, the planned arson of the torpedo loan building, which was unindicted, showed that Mr. Bryan was the leader of the criminal organization, in that he was directing how the operations were to be carried out in both instances. Now, when it comes to indicted offenses, there is a murder, eventual murder of Dooley, and here I must pause to make an observation. In this case, you have instances where persons were actually killed. Persons were actually shot. But because of the peculiarities of our criminal practice and procedure, it does not appear they could be tried on the same indictment. So in respect of count 6, which we are going to look at now, Mr. Bryan was the person who initiated the planning for this killing that eventually took place. And the persons who actually did the killing were identified, but were not charged with the actual offense of murder in this trial because of the, as I said, the peculiarities of our criminal practice and procedure that requires the murder to be tried by a jury, but offenses under this legislation to be tried by a judge sitting without a jury. That is how it stood at the time when these offenses were committed. So the accountant tells us that he and the driver were at the accountant's home along with Mr. Bryan when the killing of Dooley was planned. The accountant says that he was part and parcel of the organization and inferentially part of this planning, and his house hosted the meeting where this planned killing took place, or the planning of the killing took place. So as I had indicated earlier, there was a trip by the driver. The persons on that trip to kill Dooley were Mr. Golding, who is before the court, Mr. Johnson, before the court. Then there was another trip involving Mr. Taylor and Mr. Blake. And so, showing the existence of the criminal organization. As I said, eventually, Dooley was shot and killed. But the point here now is whether or not Mr. Bryan facilitated the commission of the murder of Dooley, and the answer to that would clearly be yes. In respect of counts 7 and 8, this is the murder of, facilitating the murder of Jermaine Bryan and Cedella Walker. This was a Fisheries incident number 2. Fisheries incident number 1 was a shooting by the National Police Academy. The Fisheries incident number 2 was the murder and arson at Fisheries away from the road and inside the community of Fisheries itself, where 2 persons died, that is Mr. Jermaine Bryan and Miss Cedella Walker. The evidence showed that Mr. Bryan was the prime motivator and leader and facilitator of this attack. The evidence showed that they had gathered by a church while they were there. What appeared to be firearms were being distributed, and in evidence, Molotov cocktails described by one of the witnesses as having gas, sand, nail, and a piece of cloth. And incidentally, the cause of death of Miss Walker and Mr. Jermaine Bryan was gunshot injuries and not from smoke inhalation or dying from being burnt in the fire. So inferentially then, the firearms were present before the shooting when they were leaving from beside the church, and when they got to where the house was, the firearms were there, the firearms were used, and that is confirmed by the cause of death as found by the pathologist. In respect of count 11 and 12. Count 11, facilitating conspiracy to murder a person called Outlaw. Count 12, facilitating the murder of Outlaw. These 2 offenses relate to the death of a gentleman, the shooting death of a gentleman known as Outlaw. And the evidence again showed that Mr. Bryan was the prime mover behind this killing. And so what we are seeing here from the shooting incident by Fisheries, the planning to burn down the torpedo loan company, the murder and arson inside Fisheries, and now this, is that, and the rest of the evidence is actually consistent with this, that no major incident took place without the approval of Mr. Bryan. Certainly no killing took place without his approval, his planning, his direction. That is very clear from the evidence. And all of these incidents up to now showed premeditation, planning, multiple attackers, use of firearm, all of them. The killing of the Rastaman, again, showed mover and architect. you are using the firearm, make sure that you hold it in such a manner that the magazine doesn't fall out. And it appears that Mr. Morris didn't follow those instructions. So when the shooting began, the firearm, the magazine, in fact, fell out, and the other individual who was there began to shoot the Rastaman. Mr. Prince was designated as the gentleman who would take the firearms after the shooting to hide them. And Mr. Blake's role in this killing was to make a determination as to whether or not the target was there. So and in respect of count 19, again, Mr. Bryan was the prime mover there in this facilitation of the conspiracy to murder person unknown. And this was now a conspiracy between himself and Mr. Prince to shoot this unknown person. So all of that now indicates that the circumstances of the various offenses facilitated, and it should be noted that in respect of Dooley, in respect of Mr. Jermaine Bryan and Mr. Della Walker, and in respect of the Rastaman, all three resulted in deaths. Even though murder isn't charged, they actually culminated in deaths. And what we have up to this point is 4 persons dying as a result of Mr. Bryan's leadership, planning, direction, and facilitation. All of these had multiple attackers, firearms, pre-planned and premeditated, arson attack in at least one, and clearly, since we know that the persons died, that is Mr. Jermaine Bryan and Mr. Della Walker, we know that they died from gunshot injuries. Plan was obvious. You go with the firearm, set the place alight. In the event that they try to escape, they'll be shot and killed. That was the plan. So either way, they're either going to stay inside there and burn to death, or they are going to be shot and killed should they try to escape. As it turned out, they were both burnt, but they died from, and shot, and they died from gunshot injuries. It should be noted as well that killing of the Rastaman, the shooting by the National Police Academy were in broad daylight. Indication then, and incidentally, no evidence that anyone was wearing a mask. So this is now a culture of impunity. I can shoot or organize a shooting anywhere, anytime, day and night. Doesn't matter. The incident by the inside fisheries count 7 and 8. That incident was nighttime. And in respect of count 19, that incident was also daytime. And I should make reference to count 25. That count failed on technical grounds. That is to say, the Crown didn't establish that ICE was alive at the time when the facilitation was done. But what was quite clear was that there was a criminal organization in existence, and they were traveling now from Spanish Town to Yorton in search of the intended target. A number of persons were identified there, including Mr. Bryan, and what appeared to be firearms were taken from top banks in the vehicles up to Yorton and then back to Spanish Town. So all of this showing persistent, consistent course of conduct that involved the use of firearms, either to kill or to cause serious bodily harm, or at the very least, wounding with intent or shooting with intent. All serious offenses. And so the cumulative evidence of the indicted counts, as well as the unindicted instances, clearly shows that Mr. Bryan was a leader of this criminal organization, and one of their purposes was murder and murder involving the use of firearms. Now, in terms of whether there were aggravating features, well, let us get to the starting point. In respect of the starting point for leadership of a criminal organization, in these circumstances here, we have identified the multiple attackers, use of guns, pre-planned and premeditation, arson where necessary, some murders committed in daylight, others by night, no evidence of efforts to conceal identity, committed over a period of time on an ongoing basis. So all of this shows that here was an organization that was operating with impunity. And so leading such an organization suggests that the starting point should be between 25 and 30 years. So in my view, the starting point here is 27 years for leadership of the organization. No aggravating factors to take it up further. But are there mitigating factors? Has no previous conviction. When we're looking now at the social inquiry report, was said to have been loved by many in the community who saw him as a positive influence. There were those who thought otherwise. It appears that his father, who began his own life in crime, later became a man of peace, later converted to Rastafarianism, and left that part of his life behind. And the report indicates that his father was suggesting to him, or at least to the mother and to Mr. Bryan, that there should be this conversion to Rastafarianism. Well, clearly the father's efforts at conversion at that time didn't produce a desired fruit. And it was Rastafarianism for the sake of Rastafarianism. The impression that I got from the report was that the father was saying this is a new way of living. This is a better way of living. So that is what the father was trying to suggest. But as I said, the father's efforts there were not successful. And so he was raised largely, if not exclusively, after a particular point in time by his mom. So while we take account of the absence of previous convictions and the opinion of some members of the community, that has to be balanced now against the way in which these crimes were committed and what led up to them. And as I indicated, they have actually resulted in the deaths of 4 persons. And so, in the context of this case, including considering the prospect of rehabilitation, it is difficult to see any good reason why the sentence on leadership should be reduced other than for the time already spent in custody. And as I indicated earlier, the evidence shows that it doesn't appear that Mr. Bryan intended to give up his life of crime unless or until he was caught by the police, which has now happened. Given the way that the organization operated, it was one in which violence was a constant part of the way in which it conducted its affairs. And that violence extended to murder and arson and shootings. So the sentence now has to be disabling Mr. Bryan from being able to conduct this kind of activity for an extended period of time. Now, in his plea mitigation, Mr. McFarlane indicated that Mr. Bryan insists on his innocence, it should not be held against him. Mr. Bryan says he's capable of reform, and I will never say that anybody is incapable of reform as a philosophical idea, as a practical, not as a practical matter, but as a philosophical idea. You can't say nobody or anybody is incapable of reform, but as to whether now, based upon the material, the evidence is there to suggest that. I must confess that I'm hard-pressed to see it, and as I indicated, it was his arrest that interrupted his leadership of the criminal organization. What the evidence shows is that Mr. Bryan was a man of extreme violence and was not afraid or hesitated to kill and to kill again and again and again to further his aims as he saw it. Mr. McFarlane indicated, which I agree with, that counts 7 and 8 should be seen together, meaning they relate to the same incident, and same argument was made in respect of counts 11 and 12, and I agree with that, but counts 6, 15, and 19 are sort of standalone in that they are not paired with any other count on the indictment, at least not just yet. So Mr. McFarlane had suggested that the sentences on count 7 and 8 should be concurrent. I have no disagreement with that. And also that the sentences on counts 11 and 12 should be concurrent. I have no difficulty with that either. Now for the offenses other than count 1, these are facilitation offense. Well, that's not quite true. They're all facilitation offenses except, well, let me rephrase it. You have facilitation of a substantive offense such as murder, and you have facilitation of conspiracy. Let's put it that way more accurately. So the count 7 is facilitation of murder. Count 8, facilitation of arson. Count 11, facilitation of conspiracy to murder. Count 12, facilitation of murder. Count 15, facilitation of murder. And count 19, facilitation of conspiracy to murder. So what I understood counsel to be saying is that at the very least, though I think he was hoping otherwise, but at the very least, in respect of the facilitation of the conspiracies, the sentences should be lower or certainly not the same as the facilitation of the substantive offense of, say, murder and arson. That is how I understood the submissions that were being made. Right. The premise being that the facilitation of a conspiracy, while serious, is not as serious as the facilitating the actual murder itself. And in principle, I don't have any difficulty with that. Right. So now, looking at, so we're going to be going now from right. So now, the facilitation offenses did three things, as I said before. They assisted in establishing that a criminal organization existed. They assisted in establishing that Mr. Bryan was a leader of the criminal organization, and that they showed that the offenses were committed over a period of time. So we're going to be grouping count 7 and 8 as one, count 11 and 12 as another, and then we'll look at count 6, 15, and 19 as standalone offenses. So having regard to the evidence as outlined in respect of counts 7 and 8, where Mr. Bryan was identified as one of the persons by the church who went over, the group of persons, along with the driver who went over to Fisheries, and what Mr. Bryan said before he went over to Fisheries. They're going to be shelling down over there, and when you look at all the circumstances, including the distribution, or at least the visible display of what appeared to be firearms, as well as the Molotov cocktail, which was in open, unimpeded view, according to the driver, made it clear that, at the very least, mayhem of some kind involving at the very least, serious bodily harm and possibly property damage would be taking place that evening. And Mr. Bryan facilitated those intended activities and facilitated the actual occurrence of those activities. So bearing in mind all the circumstances concerning count 7 and 8, and keeping in mind that the maximum penalty is 20 years, and keeping in mind as well that in respect of count 7 and 8, death of 2 persons were the outcome of the activity, it is my view that the starting point here should be 17 years for count 7. Right. In respect of count 8, starting point, in my view, should be 17 years as well, since the whole idea of going over there was to either kill the persons by shooting or by burning or both. It turned out that their bodies were burnt inside the house and they died from gunshot injuries. So in either way, whether it was by arson or by shooting, the clear intention was to kill these 2 persons. So the starting point, in my view, for count 17 and 18 should be 17 years. 7 and 8 should be 17 years. No aggravating features to put it up. Question is whether there are any mitigating features to bring it down. Having regard to all the circumstances here, I think it's a standstill, nothing to bring it up or to take it down. So we remain at 17 years for counts 7 and 8. And in particular because it resulted in the death of 2 persons. Or they resulted in the death of 2 persons. So now we come to counts 11 and 12. Count 11, facilitating a conspiracy to murder, and count 12, facilitating the actual murder of the same person. Those offenses should be taken together, as in sentences will be concurrent. So what is the appropriate sentence there? I'm just trying to find my notes here. Right. So in respect of the conspiracy to murder, facilitating that offense in respect of count 11, yes, it is connected to count 12, but count 12 resulted in the death of one individual as distinct from two. So I think the starting point should be lower. And so, in my view, the starting point for the conspiracy to facilitating the conspiracy to murder should be 10 years. That is on count 11. In respect of count 12, the starting point should be 12 years. Why 12 years? Keeping in mind that when you're dealing with count 7, there are two persons who suffered death there. Now we have a situation where you had one person, and so the sentence ought to reflect the difference between two persons dying as opposed to one person dying. I'm not saying that one life is inherently more valuable than another, but the number of persons who die should make a difference, and it does in this particular case. So, in count, did I say what the number of years should be? Respect of count 12? 12 years, right. 12 years, right. Then now you have count 6. Which is a standalone count. And trying to give effect to the different principles and weighing the different principles that I outlined earlier in respect of count 6. It resulted in the death of one person. It's a shooting death, similar to count 12. I mean, there are differences in the sense that in respect of count 12, it is said that Mr. Bryan drove by or was near to the vicinity of where the gentleman in count 12 was shot and killed, but that is not a sufficient difference to make it more aggravating or less aggravating, as the circumstances are very similar. So in respect of count 6, the starting point is also 12 years there. We're now at 1, 2, 3, 4. Count 15. That involved the murder of the Rastaman that was facilitated, planned and encouraged by Mr. Bryan. So the starting point there, to me, again, is 12 years. And that takes us to count 19. That was facilitating conspiracy to murder someone unknown. Very similar to count 10. And so the starting point there is count 11. Count 11 is 10 years. It's 1, 2, 3, 4, 5, 6. There's one that's missing. I've dealt with counts. Just a moment. 1, 2, 3, 4, 5, 6. I dealt with counts 11 and 12. Have I covered all of them? Yes. Right. Just making sure. Right. Right. So where we are now is right. So count 1, I said was 20, 27. Right. So starting point then for count 1, 27 years. Count 7 and 8, 17 years each. Count 11 and 12, count 11, 10 years. Count 12, 12 years. Count 6, 12 years. Count 15, 12 years. Count 19, 10 years. Starting points. Now, as I said, in none of these, I see any aggravating factors to increase the number of years. Are there any mitigating factors in these circumstances to warrant a reduction, other than the fact of no previous convictions? I am not convinced that there are any mitigating factors here to warrant any reduction. So the starting point remains the end point. So what Mr. Bryan has been in custody 5.5 years. So when they take away the 5.5 years, so in count 1, that leaves us with 21 and a half years. 5 from, yes. For count 6, that leaves us with 6.5 years. I'm going to reduce for all counts. All counts. Respect of count 7, that would be 11.5 years. For count 8, it's 11.5 years. For count 11, that's 4.5 years. For count 12, that's 6.5 years. For count 15, that's 6.5 years. And for count 19, that's 4.5 years. Okay. Now, I'd say that I'd agree with Mr. McFarlane that the sentences on counts 7 and 8 should be concurrent. So, sentences on counts 7 and 8 are concurrent. So that's 11.5 years here. In respect of the sentences on count 11 and 12 concurrently, to run concurrently, so that gives you a maximum there of 6.5 years. Right. So that leaves us now with counts 6, 15, and 19, and what to do with them. And count 1, what to do with them. Now, in this case, I think that the question of consecutive sentences should be considered. What is the principle relating to consecutive sentences? In principle, it's permissible. What the decisions indicate is that where the offenses arise out of the same circumstance, then in principle you should not have consecutive sentences. The court should look to see whether they can have a substantial sentence on the major offense, and then the other sentences be made to run concurrently along with the major offense. But consecutive sentences are appropriate if the circumstances are such that the sentences, unless made to run consecutively, would not reflect the true criminality of what was involved. Here we have a gentleman who was a leader and a part of an organization that involved murder, shooting, and at least arson as well. We have a situation in which 4 persons died. Yes, 4. Part of count 19. We had Dooley, we had Mr. Bryan, Miss Walker, Outlaw, and who else? And the Rastaman. There's 5 persons who died as a result of his activity. But for, as I said, the quirk in our criminal practice and procedure, he may very well have been prosecuted for the full offense of murder. But we are where we are with that. So, in my view, there should be consecutive sentences to reflect the full scope of the criminality and to ensure that the level of offending, the scale of the offending, the scope of the offending, the extent of the offending are adequately addressed at this phase of the trial. So, this is where we are now. So I have count 1, which is 23 years. Right. Let me cut and paste here. Cut. Right. Count 1, which is 21 and a half years. And I had indicated that the unindicted offenses had established that Mr. Bryan is a leader of the criminal organization. And then the indicted offenses also established that he was a leader of the criminal organization, but they extended the scope over which the offenses occurred and therefore enabled the Crown to adduce all of that evidence to establish that he was the leader. And in that context now it was leader of a violent organization. So that is how we end up now at the 21 years. I have also said that the sentences on count 7 and 8 are concurrent, and the sentences on counts 11 and 12 are concurrent. So, the sentences now on counts 6, 15, and 19. Yes? Count 6, 15, and 19 are to run concurrently with the sentence on count 1. Sentences on 6, 15, and 19 to run concurrently with the sentence on count 1. Got that, Mr. Registrar? Got that? So you have the sentence for count 1 and the sentence for counts 6, 15, and 19 to run concurrently with the sentence on count 1. Got that? Okay. Right. Now, the sentence on counts 11 and 12. With me so far? Sentences on counts 11 and 12 to run consecutive to the sentence on count 1. With me so far? And now the sentences on counts 7 and 8. Yes? Sentences on count 7 and 8 to be consecutive to the sentence on counts 11 and 12. With me? The sentence is on counts 11 and 12. So the sentence on count 6, 15, and 19 concurrently with the sentence on count 1. Sentence on count 11 and 12 consecutive to the sentence on count 1. And count 7 and 8 consecutive to the sentences on counts 11 and 12. Everybody got that? There's 2 consecutive sentences. You got that? I've covered all the counts. I've covered all the counts, yes? So it's 21 and a half plus 6 and a half plus 11 and a half. It's 21 and a half plus 6.5 plus 11.5. That's a total of 39.5. Got that? Got that, Madam Court Reporter? Okay, right. So that's it then for Mr. Bryan. You can please remove him from the dock, please, Mr. Bryan. That's 39.5 years in all. Okay? Right. Okay, we'll take the adjournment now and return at. They're still taking lunch for them? Adjourn until 2:30 then.
Stand, please. This honorable court stands adjourned until 2:30 p.m. God save the King. This honorable court is now resumed. God save the king. You may be seated, please.
May it please you, my lord. The continuing matter of the Queen and Mr. Andre Bryan, Mr. Tomrick Taylor, Mr. Michael Whitley, Mr. Dylan McLean, Mr. Lamar Simpson, Mr. Tariq James, Ms. Stephanie Christie, Mr. Fabian Johnson, Mr. Jazeel Blake, Mr. Royal Taylor, Mr. Joseph McDermott, Mr. Jermaine Robinson, Mr. Andre Golding, Mr. Brian Morris, and Mr. Ted Prince, all jointly indicted for breaches of the Criminal Justice Suppression of Criminal Organizations Act. Representation remains the same, my lord. Trial commenced on the 20th day of September 2022 and concluded in March of 2023. Where for the sentencing hearing, my lord, may it please you.
Yes. Roll call, please.
Yes, sir. Ladies and gentlemen, Mr. Michael Wiley. Thank you. Mr. Dylan McLean. Mr. Lamar Simpson. Mr. Tariq James. Thank you. Ms. Stephanie Christie. Mr. Fabian Johnson. Mr. Jazeel Blake. Thank you. Mr. Royal Taylor. Mr. Joseph McDermott. Mr. Jermaine Robinson. Mr. Andre Golding. Mr. Brian Morris. And Mr. Ted Prince. Thank you all. All present, Chief Justice.
Lord, I wish to make a correction. Trial actually commenced September 20, 2021, not 2022.
Very well, yes. And so now we are at Mr. Michael Whitley. And he was convicted on counts 2 and 15. He was convicted after a contested trial of membership of a criminal organization. And count 15 is in respect of the murder of the Rastaman on Jones Avenue. The evidence is that Mr. Whitley was at Jones Avenue when he and Mr. Morris were told that they were going to kill a Rastaman by Mr. Bryan. The evidence disclosed that Mr. Bryan sent another of the gang members, known as Mackerel, for 2 firearms, and they were handed to Mr. Whitley and Mr. Morris. The accountant, one of the witnesses for the Crown, was told to take them into Jones Avenue. It was the case that Mr. Prince was to go down the lane and wait on Mr. Whitley and Mr. Morris. His role was to hide the guns after the shooting. This was a case in which Mr. Morris was given instructions about how to use the firearm, and part of the instructions from Mr. Bryan to the men was that the shooting was to be done in such a manner, so that it made it appear as if Della men were responsible for the shooting. Mr. Morris, it appeared, did not follow the instructions carefully, and during the shooting, the magazine fell from the firearm. Mr. Whitley, according to the evidence, ran up and shot the Rasta man. Mr. Morris, it is said, retrieved the clip and continued shooting the Rasta man, and then both men ran off. In this circumstance, the maximum penalty for being a member of a criminal organization is 20 years. The maximum penalty for facilitating the serious crime of murder is 20 years. Now, the social inquiry report indicates that he's maintaining his innocence. He says that the witnesses are lying on him. The SCR also indicates that there's no established pattern of offending, and that from their standpoint, this is not an escalation of serious offending, because it is Mr. Whiteley's first conviction. The SCR, the Social Inquiry Report, goes on to indicate that his mother was quite distressed to hear about his involvement in a gang, but she said that he had not been living with her for some time, so she does not have much information about the persons with whom he associates. The residents of Jones Avenue indicated that he was not a source of trouble in the community, but, to use their words, he took up badness in Lauriston. Despite this view, they were surprised to hear of his gang affiliation, as they saw no evidence of it. Though they said, well, they couldn't say what his behavior was like after he left their presence in Jones Avenue. So that is what the Social Inquiry Report has to say about him. He's 25 years old. His attorney said he's not beyond redemption. He has suffered loss in his life, namely that he had one child that has unfortunately died. His attorney referred to the assistance he would give his mother, who was operating a restaurant, is a small business operator, and since his incarceration on pretrial remand, the assistance is no longer there for his mom, and so the business has collapsed. Council is suggesting that the starting point here should be 10 years, and that he has been in custody 5 years, 5 months, and 2 weeks. And Council emphasized the absence of a pattern of offending, and it was also pointed out that the defendant recognizes the impact of the offenses on the community. Now, in determining the starting point, in accordance with what I had indicated from Aguilera and others against the state, look at the circumstances of the offense without reference to the particular features concerning the defendant. This was a premeditated attack on the Rastaman. From the evidence, it is not quite clear why this Rastaman was targeted, and not only was it premeditated, but Mr. Bryan was the prime mover and gave detailed instructions, even to the point of how to use one of the firearms in question, because apparently it had some kind of defect that would cause the magazine to fall, which, based upon the evidence, the magazine did fall from the gun. And the other person who was to assist in the shooting made sure that the target was shot. The magazine was retrieved and the firing continued by the person who retrieved the magazine. This was a murder in broad daylight, a clear indication that fear of identification was not one of the things that the perpetrators thought of. There was no evidence that there was any effort to disguise their appearance or to cover their faces. So this was a brazen attack on a citizen in daylight by 2 armed assailants. The planning, which Mr. Whitley was a part of, extended to what should happen to the firearms after the shooting. So there was premeditation and thinking through what should happen after the shooting, in effect, how to escape detection. So the idea being that in the event that someone notified the police and the police intercepted Mr. Whitley and Mr. Morris shortly after the event, the argument would be, but I don't have any firearm with me. And the explanation is that Mr. Prince was to take the firearm and to hide it. So those are the factors now which we look at in a context in which the maximum penalty on both charges is 20 years. Looking now at the starting point, in my view, has to be on the higher end, since it involved not just the planning, but the actual death, and before the court, based upon the evidence, we actually have, as we'll see as we go through the rest of the sentencing, the two persons who were responsible for the death of the Rastaman, Mr. Whitley and Mr. Morris. So you actually have the shooters here, but again, because of the principles relating to criminal practice and procedure, Mr. Whitley, the actual shooter, one of them, could not be tried for the offense of murder in this trial. And so what the criminal practice and procedure now has created is this. This is the risk that is created, that the evidence shows that he was one of the shooters. But if he's tried for the actual murder before a judge and jury, it creates the risk now of an acquittal. So what you would have is a man who has been proven to be one of the actual shooters, convicted for facilitating murder. But if you have the trial on the actual murder, there's a possibility that he may be acquitted. Now, something has to be wrong with criminal practice and procedure that allows that possibility. Has to be defective. So the same evidence can be accepted by Tribunal A in one trial, and the same evidence rejected by Tribunal B in another trial. Something is wrong with that. But anyway, we are where we are. So, in these circumstances, I think the starting point of 17 years, certainly in respect to the facilitating the murder, if for no other reason other than the evidence shows that he was the actual, one of the actual shooters, and the entire circumstances leading up to the killing showed that he was a member of the criminal organization. He knew what he was being asked to do, i.e. to go and shoot this Rastaman. He got the firearm, went down there, and did what was required of him. So certainly in respect of facilitating, starting point is 17 years. In respect of the membership of the criminal organization, now he has chosen to be a member of an organization that, to his certain knowledge, involved in the business of murder and provided with a firearm, and based upon the evidence, not his own firearm. So Mackerel was the one who went to get this firearm from wherever it was, brought it back, so he's now getting the tools of the trade. And the planning extended to how to secure this vital tool of the trade, the firearm, after the shooting. So if you choose to be the member of such an organization, then of course one should expect that if you're caught and tried and convicted, then the punishment should reflect the consequences of the choice that you have made. So, the starting point, in my view, for this membership of a criminal organization should be 16 years. Are there any aggravating factors that put it up to 20 No, I don't think so. So, again, not discounting human life, but there's nothing in the circumstances that would make it any more egregious than, unfortunately, what has become regular types of murders experienced in Jamaica. Counsel has indicated that he's, and the report has indicated that he's 25 years old, so those are the mitigating factors now to see whether it brings the starting point down, and not just 25 years old, but no previous conviction. Also, it is one person who was killed here, as distinct from other circumstances. We had as many as 5 persons. We have one here. So, in both instances, that will take down the number 3 years from each, so that takes it down to 14 years. And according to the evidence, he has been in custody, 5.5 years? I think that is what the court was advised. Let me double check here. Well, it's 5 years, 5 months, and 2 weeks, but we call it 5.5 years. So 5.5 from 14, that's what, 9? 5 from 14 gives you 9. And then you have half a year. So that's what, 13.5? Yes. Gives you 9.5. 8.5. 8.5, I'm sorry. 8.5. Yes, sir? Yes. Excuse to where? Okay. So we'll await the return of one of the defendants. Right. So, Mr. Registrar, right, just had a break because one of the defendants had left the court. Let's do the roll call again to ensure that everyone is here.
Ladies and gentlemen, Mr. Michael White, Mr. Dylan McLean, Mr. Lamar Simpson, Mr. Tariq James, Mr. Christie, Mr. Fabian Johnson, Mr. Jazeel Blake, thank you, Mr. Royal Taylor, Mr. Joseph McDermott, Mr. Jermaine Robinson, thank you, Mr. Andre Golin, thank you, Mr. Bryan Morris, and finally, Mr. Ted Prince. Thank you all. All present, Chief Justice.
Right. So now, yes, we're now down to 8.5 years on counts 2 and, beg your pardon? Has to be 8.5 because you come from 17, drop it by 3, then you take 5 on both count. Oh, I said 16 for 1. Oh, right. 7.5 on count 2 and 8.5 on count 3. Right. You're correct. So it's 7.5 on count 2 and 8.5 on count 15. So the question then becomes now whether the sentences should be concurrent or they should be consecutive sentencing. Now, as I indicated, the principle is that, general principle is that where the circumstances giving rise to both offense, or both offenses arise out of the same circumstance, in the normal course of things, the sentence should be concurrent. But there's also the question as to whether or not, if the sentences are concurrent, it is sufficient to recognize the gravity of the offending. And that becomes an important consideration here because, based upon the evidence, Mr. Whitley was one of the persons who actually engaged in the shooting death of the Rastaman. And so having a concurrent sentence would not be sufficient recognition of his own culpability in the death of this person. So I think that this is an appropriate case to have consecutive sentencing so that the sentence on count 1, the sentence on count 15 is to be consecutive to the sentence on count 2, so that's 7.5 for count 2 and 8.5 for count 15. That makes it a total of 16 years for Mr. Whitley in respect of the conviction on count 2 for membership and count 15 for the murder of this Rastaman. So that is it in respect of Mr. Whitley. Now, the It is, where is Mr. Morris? Where is Mr. There you are, Mr. Morris. Yes, it is appropriate to deal with Mr. Morris at this point. He was convicted on counts 2 and 15, very, well, virtually identical circumstances to that of Mr. Whitley, and much that has been said there applies to Mr. Morris. So Mr. Morris, like Mr. Whiteley, was given express instructions as to who they were going to kill and where the person was supposed to be. And he did just that. And we know from the evidence in the case that before the shooting, Mr. Bryan expressed the view that he wanted Mr. Morris to do the shooting because in Mr. Bryan's view, no one from the lane knew Morris, but they knew Mr. Whiteley. So that was part of the planning as well. And of course, the expression of the desire to make it appear as if persons from another community had done the shooting was undoubtedly designed to cause any reprisal to take place in the De La Vega community and not within Jones Avenue itself, should there be reprisal killings. So Mr. Morris then was, again, like Mr. Whiteley, the other of the actual shooters in this particular case. As far as the social inquiry report is concerned, Mr. Morris maintains his position that he is not a part of any gang and does not know anything about the gang's activities, and he has been wrongly identified and accused by the witness. And of course, he says of all the names mentioned in court, the only person he's familiar with was the witness himself, with whom he played football on the weekends, but they were not friends. And so that is what he had to say to the probation officer. Well, the probation officer continued their report, and they indicated that Mr. Morris has no previous convictions, no pattern of serious offending. So those are things in his favor. He is 28 years old now, approximately 24 years old at the time of the incident. The parents of Mr. Morris were interviewed, and they described him as a quiet individual, shy, kept few friends, and they were quite shocked when they heard of his arrest and what he was arrested and charged for, or charged with. His mother in particular indicated that it was not until this case arose that she learned that he may have been connected with a gang operating in the community. And perhaps that is not surprising, since it says that in recent years she had spent a lot of her time outside of the Jones Avenue community. Both parents were hard-pressed to accept that their son was involved in this kind of activity. And of the aliases that he had, he was known to at least the father as Bird, only to become known as Rooster at a later point in time. As far as the community report is concerned, when the probation officers went to Lauriston, the few persons there who were willing to speak, they recognized him to be the son of, well, the gentleman who is identified as his father. They said he grew up in the community, and in their view, he was doing well for himself until he began associating with the gang, and in their view, it changed him for the worse. And those who were willing to speak expressed the view that they preferred him to remain where he is, not so much for peace and quiet, but in the interest of his own mortality, should he be released. So that is what the community members had to say about Mr. Morris. So while it is true that he has no pattern of offending, but based upon the evidence, he was one of the actual killers of the Rastaman, so has to start high up on the sentencing scale. So same way with Mr. Whitley, 16 and 17 years respectively, 16 years for the membership and 17 years for the facilitating the murder. And so far as the mitigating factors are concerned, take away 3 years, so we are down to 13 and 14. He has been in custody well, I should have indicated there's no aggravating factor to put it higher up. So they're going to, so it remains at 16 and 17. And then now for the mitigating factors, no previous conviction, no escalation, being 28 years old, and so on and so forth. So that's down by 3. That's how we got to the 13 and 14 respectively. He has been in custody 4 years and 3 months. So the law now requires sentencing judges to deduct that time. So 4 years from the 13, that would give you 9, and the 3 months, that would give what? 8. 4 from the, yes, 8 years and 9 months. Right. 8 years and 9 months. And 4 years from the 14 gives you 10. And then 3 months, that's 9 years and 9 months. As I said, now we have the actual shooter here. And so to follow the normal principle of having them run concurrently would not be sufficient to indicate the seriousness of what has occurred here, because, as I said on the evidence, Mr. Morris is the actual shooter, or one of the actual shooters. And so it is appropriate that there be consecutive sentences to reflect the fact that he was one of the actual killers. And so the sentence on count 15 is to be consecutive to the sentence on count 2. So that would make it 9 and 7, 9 and 8, 17, 9 and 3, 12. So that would be 18 years and 6 months. So, Mr. Morris, it's 18 years and 6 months, sir. So that's that. So we are now at Mr. Dylan McLean. He was convicted on counts 2, 7, and 8. Where's Mr. McLean? Oh, there you are. Yes, Mr. McLean was convicted after a contested trial. Mr. McLean, based on the evidence, was present when Mr. Bryan spoke about shelling down fisheries. This was now the fisheries inside the community and not the shooting by the National Police College. He was part of the group that was heading over to fisheries where Mr. Jermaine Bryan and Miss Stella Walker were killed. According to the evidence, Mr. McLean was one of those armed with a firearm. Now, there is no evidence that he was actually at the scene of the murder and arson, but it is clear that by being present at the church where the planning was, he provided support and encouragement and facilitated the murder and arson which eventually took place. That he was a part of the criminal organization is not in doubt. Again, the maximum penalty on counts 2, 7, and 8, 20 years on each count. Now, looking at the circumstances here, Mr. McLean readily lent himself to this enterprise. While he was there, it was clear that violence was intended. He had a firearm, and this was also, they had the, what I call the Molotov cocktail, that was in evidence before the persons departed from the vicinity of the church. So he would have known, both from what he would have observed and also what was said by Mr. Bryan about the shelling down over by Fisheries, what was intended. And as our statute says, if three or more, and there were more than three persons there, have as their purpose the commission of one or more serious offense, and they're in a group or they're affiliated in some way, then that is sufficient to establish the existence of a criminal organization. And persons are armed with Molotov cocktails, gas, sand, bottle, wick. Doesn't require much imagination as to what it was intended for. If one is armed with a gun, going over to Fisheries to do some shelling down, doesn't require much imagination to figure out what was the expected activity on arrival at the scene. So, there is no evidence that he was actually at the scene of the shelling down and the shooting and the burning. So that has to be taken into account when viewing the circumstances to determine the starting point in relation to Mr. McLean. And on 7 and 8 are going to be viewed together, and the remaining question would be whether it would be consecutive or concurrent sentences, which we'll get to in due course. So what is the starting point here? Having regard to his involvement and the evidence that indicated membership, the starting point in this case for membership is 14 years, and the starting point for count 7 and 8 is 15 years. The report tells us no previous convictions, no pattern of offending, no escalation, and the circumstances do not indicate any aggravating circumstances to increase the starting point upwards. So it remains at 14 and 15 years. Question is, are there mitigating factors that would reduce the sentence the starting point downwards. Yes, we have referred to them. So it's 3 years and 3 years and 3 years. That is, in respect of membership, we are down to 11 years. And in respect of count 7 and 8, we are down to 12 years. Now, where was it? I thought I had made a note of it here, but just remind me, counsel, he was in custody, what, 4 years? It's 4. Nine months. Okay. So they've been in custody 4 years and 9 months. So that must be deducted. So it's 4 years from the 11, gives us 7 and 9 months. So that's what? 6 years and 3 months. On count 2, which is a membership. Count 7 and 8. So that's what? 4 from 12, that gives you 8. So that's what? That's what? In respect of count what? Right. 7 years and 3 months. Right. So it's 6 years and 6 years and 3 months for count. Right. Now, the question now remains as to whether this should be concurrent or consecutive. Now, the evidence does not indicate that Mr. McLean was actually at the scene doing any of the shooting and burning. His facilitation would have come earlier on in the process when they were by the house. And it is the same circumstance that the Crown is relying on to prove membership of the organization. So, in the circumstances, the sentences on counts 7 and 8 are to run concurrently, and the sentence on count 2 is to run concurrently with the sentences on count 7 and 8. So what we have then is concurrent sentences, gives you 7 years and 3 months in respect of Mr. McLean. So it's 6 years and 3 months on count 2, and on count 7 and 8, 7 years and 3 months, all sentences to run concurrently, giving a total of 7 years and 3 months. So that's it, Mr. McLean. Right, so this takes us now to Mr. Lamar Simpson. Yes, Mr. Simpson was convicted after a contested trial on the sole count of membership of a criminal organization. Now, Mr. Simpson, based upon the evidence, was part of the group that went in search of someone called ICE. That was count 25. And we have already noted that that count failed for a technical legal point, but the court had decided that the evidence was still of value to demonstrate that Mr. Simpson was part of a criminal organization. And this is a trip now that originated in Spanish Town and ended at Yorton, and the target wasn't found. So the group returned. So what this evidence showed was that Mr. Simpson was part and parcel of this group that made this trip in search of ICE. There were weapons described as firearms that were taken on this trip. And so those are the relevant facts for the purposes of sentencing. Now, there is nothing to indicate that Mr. Simpson was party to any shooting or arson or anything of that nature. And in this particular trip, no acts of violence occurred. And so in determining the starting point for Mr. Simpson, all those factors will have to be borne in mind. Now, to willingly lend yourself to go in search of a person, and the circumstances indicated that they're looking for this person to kill him, has to be taken seriously. And so there also has to be a distinction in the starting point where there is no evidence that Mr. Simpson or the group shot at or did anything to carry out their purpose. They went in search, the person wasn't found. And so the starting point then for Mr. Simpson would be 10 years, since to voluntarily align yourself with such an organization is always a serious matter. No aggravating circumstances to increase the starting point. In terms of mitigating factors, has no previous convictions and no indication that this is an escalation. I suppose that inevitably follows from no previous convictions. So, social inquiry report from Mr. Simpson indicates that he enjoyed his youth engaging in the usual activities that young men engage in, sports. His mother ensured that he was a regular attendee at a church located at Young Street, and his mother quickly recognized that he wasn't the kind of child who was going to see the education process through to CXE or CSEC. So she made the decision to have him enrolled in a skills training program to become a mason. Apparently he started the program, and then when he received early employment, he did not return to complete his certification. He became a father at approximately age 18 years. And contact was made with the mother of his child, who had the highest of praises for him, described him as the best man that she has ever had. She even described him as decent, hardworking, clean, responsible, and family-oriented. The one problem that she had with him is not really relevant for current purposes, and that's a matter between himself and the mother of his child. But she speaks highly of him. His mother indicates that he's a jovial, responsible, and family-oriented young man, enjoys a good relationship with his mother. She says that he loves to work and takes pride in caring for his children. As far as the community report is concerned, this is at Oxford Street. They say, as far as he is concerned, they describe him as sociable, worked hard to care for his sons. They said that his current circumstances is unfortunate. And as far as they are concerned, he's not a member of any gang. And they say that if he is guilty, it must be by virtue of guilt by association. And they are asking for him to be released immediately, or the minimum sentence be imposed. So what all of this is saying is that Mr. Simpson is not seen by members of the community as a threat to them. So both the persons within his family, that is the girlfriend and his mom, and the report from the community members are consistent. And in the absence of any additional information to suggest otherwise. These are things that should count in his favor. So what our starting point was, what was it now, 10 years? So these things now, I think, would reduce his time by 4 years down to 6. And he has been in custody 4 years and 6 months. So 4 from 6, that's what? 2. And then 6 months, that's 1 year and 6 months. So yes, Mr. Simpson. Yes, sir. The sentence on count 2 is 1 year and 6 months. That's 18 months. So that's it, sir. Yes. Now, in the time remaining for today, we're going to skip over Mr. James and get to Miss Christie. Miss Christie was convicted on 1 count. That is membership of a criminal organization. And she was now identified as one of the persons who went on this trip in count 25. She was also identified as one of the persons involved in the planning of this intended arson of the torpedo loan company. In addition to that, she was described by one of the witnesses as the go-between between the organization and the police, and by that he meant that whenever persons were arrested, she would be engaging the police in order to extract as much information as she could. And this was borne out to a significant extent by the evidence of the retired detective inspector who spoke about his contact with her, that she was indeed trying to extract information from him concerning matters relating to the police investigations into the criminal organization. I'm saying all of this to say that the evidence suggests that Mrs. Christie was not an incidental or casual member of the organization, but an integral part of the operations of the organization. And in fact, if one recalls some of the telephone conversations in which she's recorded, it is clear that she was a strong and ardent supporter of Mr. Bryan and the conversations that were admitted into evidence revealed that she was quite upset that some of the persons who were assisted by Mr. Bryan were so ungrateful and really should have been displaying far more loyalty to him than they were actually displaying. So all of that suggests that she was indeed deeply involved in this criminal organization, albeit that other than the trip up to Yorton, it does not appear that she went to any other or made any other trip to commit any crime, but certainly she was an integral member of the criminal organization. And so she has to be viewed from that perspective. But there's one thing that I need to find here that I'm not seeing at the moment. Give me a few moments, please. And I'm having a bit of difficulty here with the technology. It has refused to cooperate any further for this afternoon. So we'll continue tomorrow morning at 10 with Mrs. Christie. So we'll take the adjournment now until 10 a.m. tomorrow morning.
Stand, please. This honorable will stand adjourned till tomorrow, Tuesday, the 3rd day of October 2023 at 10 a.m. God save the King.